Good morning, everyone. I'm going to give you all a minute to get in from the waiting room. We have a lot of people registered, so everyone logged on. And I'm working on getting the closed captions up and running. So when those are live, you'll see a red live box on your screen, and you can click on that to see the closed captions. And I will also put that link in the chat box just in case you have trouble going directly there. All right, closed captions are up, and there's the link in the chat box. Well, good morning, everyone, and welcome. I'm so glad you could join us today for the nuts and bolts of appellate practice. Don't worry, I'm not going to try to attempt to teach you that. Luckily, we have Amy Wessel Jones here. She is a partner in the appellate practice group of Shutts Bowen, and I'm so happy to have her here today. She is an expert in this field, and she's got a lot of material to cover. So we're going to go ahead and hold questions until the end. And also because it's a lot to ask of one speaker to talk for 2 hours straight, we're going to take a 5-minute break around the 11 o'clock mark, just to give everyone time to stretch and re-engage. I know that's a long time to be on Zoom. So this is being recorded and will be sent out to everyone after the webinar. And CLE has been approved, so I will announce that at the end. And at this point, I will give it to Amy Wessel Jones to take away. Thanks again, Amy.
Thank you, Christy, for that introduction, and thanks to you all for joining us this morning. I really respect and appreciate the work that you guys do for the underserved in our community. So I'm excited to be here today to share a little bit of knowledge about appellate practice. So let's get into it. So the goals of today's presentation are to acquaint you all with preservation of error at the trial court level, appealability of various types of orders, the mechanics of an appeal, standards of review on appeal, key appellate doctrines, and then we're going to discuss a few of the recent amendments to the Florida Rules of Appellate Procedure. And my focus today will be primarily on Florida civil state appeals, not criminal, not federal appeals, just to note that. So let's start out by talking about the concept of preservation of error, which means the appellate court will generally not consider an argument that's raised for the first time on appeal. Instead, the argument must be raised at the trial level in order to be cognizable on appeal unless fundamental error has occurred. And we'll discuss fundamental error a bit later in the presentation, but for now, just keep in mind that it's extremely rare for fundamental error to be found in civil cases. So what does that mean for trial attorneys? That means that the key to a successful appeal starts at the trial court level. So to preserve an error for appellate review, you must make a timely contemporaneous objection, state the specific legal basis for the objection, obtain a definitive ruling from the trial court, and the argument that you raise on appeal has to be the same as the argument that you asserted below. We're going to take a little bit of a look at each of these elements in depth. So the first requirement is to make a timely contemporaneous objection. Whether an objection is timely will depend on the specific issue involved, but generally you must object at the time of the alleged error. However, there is a little exception here, and that's where the objection is made in time for the trial court to take corrective action. And that, even if it wasn't made at the exact time of the alleged error. So for example, in the Jackson case that I've cited here, the court explained that objections to questions posed to a witness need not always be made at the exact moment when the examination goes into an impermissible area of inquiry. Rather, as long as the objection was made during that specific line of questioning, it was deemed timely because the trial court had enough time to sustain an objection and issue a curative instruction. So, but a practice pointer here, object as soon as possible, because once the testimony is given or the evidence is admitted, it might be too late for the trial court to offer an effective remedy. However, if you find yourself in a situation where you just forgot to object or you just didn't object right away for some reason, you might be able to use this Jackson case to argue that your objection was timely if you made it during that line of questioning. So the second requirement is that you must state the specific legal ground for your objection. So for instance, if you're objecting to the introduction of certain evidence, it's not sufficient to just say objection or inadmissible. You have to state why the evidence is inadmissible. So for example, it's hearsay. And the purpose of this requirement is twofold. A specific objection lets the trial court know what you believe the error is, and it also then allows the appellate court to intelligently review the issue later. However, when you're making an objection, there's a lot of case law that says no magic words are required as long as your objection is specific enough to inform the trial court of the nature of the alleged error. So for example, in the Harding case that I've cited here, even though counsel didn't use the exact word propensity, it was apparent from, the rest of his objection that that was the basis for his objection. So that was deemed sufficiently specific. The third requirement is you must obtain a definitive ruling from the trial court. So if the trial court defers ruling on your motion or objection, or if you withdraw it before there's a ruling, or if the trial court merely recognizes a stipulation of the parties, you haven't satisfied this requirement. So for example, in the Collins case cited here, the trial court simply recognized that the state had agreed with the defense's request to exclude certain evidence, but then the state actually presented evidence on that issue at trial anyways. And the appellate court held that a pretrial objection wasn't preserved because the trial court hadn't actually made a ruling admitting that evidence. He had simply recognized the party's stipulation to exclude it, and defense counsel didn't renew any objection at the time the evidence was offered. There's an exception to the definitive ruling requirement where the trial court just blatantly refuses to rule, but be careful not to confuse that with a deferral of ruling where the trial court says, I'm going to take this under consideration and I'll rule at a later time, because the deferral of ruling is not deemed to be definitive. Whereas if you try and the judge just says, I'm not ruling on this, then that alone can be, you can get around the definitive ruling requirement. And the rationale for this requirement is that appellate courts are error correcting courts. So if the trial court never even ruled on an issue, then there's really no error for the appellate court to correct. And just a quick practice pointer here, if the trial court's ruling is ambiguous in any way and you're just not sure if you've obtained a definitive ruling, just ask for clarification, or you can even restate what you think the ruling is and have the trial court confirm that for you. The fourth requirement is that the argument you raise on appeal has to be the same as what you raised below. So for example, if you objected to the admission of evidence based on hearsay, you can't argue on appeal that the evidence should have been excluded for some other reason, such as irrelevance or something along those lines. However, the argument that you raised below doesn't have to be articulated with the same level of detail as presented on appeal to be deemed preserved. So the argument in your appellate brief can be a lot more detailed than the argument that you raised as a trial court, as long as it's the same general argument. And the policies behind the preservation of error rule, there are several. The first is fairness to the trial court and practical necessity. Because, as a matter of judicial economy, it makes sense to give the trial court the opportunity to correct the error before you're allowed to raise it on appeal. The second policy is fairness to the opposing party, in that it gives your opponent the chance to correct the error at trial and avoid its prejudicial effect. So, for example, if you object to the admission of evidence on the basis that there's been an inadequate foundation laid, if you raise that issue at trial, then your opponent could potentially lay that foundation and get around, the prejudicial effect of that error. And finally, the rule also prevents gamesmanship. So in the Nissan case I cited here, the court noted that a party can't simply wait around and see what the outcome of trial is, and then if it's unfavorable to your client, then you start objecting to a whole bunch of errors that occurred earlier. So now that we have this general framework in mind, we'll discuss some of the specific applications of the rule during various stages of litigation. So preservation requirements apply from the very outset of the case, starting with the complaint. So if you're the plaintiff, make sure you plead all theories and claims for which you seek to hold the defendant liable. You also must ensure that the complaint requests whatever relief you're seeking from the court. The same principles apply with affirmative defenses. Most defenses have to be raised at the trial level or they're deemed waived. So even if you have, for instance, a completely viable statute of limitations defense, if you didn't raise it below, the appellate court is not going to consider that for the first time on appeal. There is an exception for trial by consent, which we'll discuss a little bit more in depth later, but the gist of that is that if one of the parties presents evidence on an unpled claim or defense and the other side doesn't object, then you're deemed to have tried that by consent, and the court can enter judgment on that theory or claim. So next is the summary judgment phase. If your opponent moves for summary judgment but doesn't abide by the requirement that the summary judgment motion and evidence be filed at least 20 days before the hearing, make sure you object to that at or before the hearing, or you could be deemed to have waived that issue. So in the Vidal case cited here, the appellant argued on appeal that the trial court erred in considering summary judgment evidence filed less than 20 days before the hearing, but the appellate court rejected that argument because the court noted that the appellant had simply defended on the merits and hadn't raised the untimely issueness below. Similarly, defects in summary judgment affidavits, if your opponent has filed one that you think, for instance, the affiant, didn't have a basis for didn't have personal knowledge or any other defects that you can identify, you must file a motion to strike the affidavit before the hearing, or at a minimum, raise it at the hearing. Otherwise, you can waive that issue. However, there is quite a bit of case law that's come out in the last few years that holds that if the trial court fails to hold a hearing on a summary judgment motion, that is fundamental error that can be raised for the first time on appeal, even if you didn't object to that below. And I've cited a few cases there. And the rationale behind that is that because Rule 1.510 expressly references a hearing, the denial of due process occurs if the court rules on the motion without holding a hearing. Also note that, I'm sure most of you are aware of this, but effective May 1st, 2021, Florida is amending the summary judgment rule to adopt the federal summary judgment standard. So be sure you're arguing the correct standard as of May 1st. And there were two opinions issued by the Florida Supreme Court at the end of last year on this issue. I've cited them here, but so in the In-Re Amendments case, the Florida Supreme Court identified three particularly consequential differences between the federal standard and the Florida standard. So first, unlike Florida law, federal case law recognizes the similarity between summary judgment motions and directed verdict motions. Second, the court explained that the movement no longer has to conclusively disprove his opponent's claim or provide summary judgment evidence affirmatively negating his opponent's claim. Rather, you can now, or as of May 1st, you can point to the absence of summary judgment evidence supporting your opponent's claim. And third, the court also explained that Florida has historically taken a much more expansive view of what constitutes a genuine issue of material fact. So in Florida, you used to be able to just point to any evidence, no matter how incredible or trivial, and even if there was the slightest doubt, that would preclude summary judgment. But under federal law, the standard is whether the evidence is such that a reasonable jury could return a verdict in favor of the non-moving party. So as of May 1st, the non-moving party's burden in attempting to defeat summary judgment will be higher. So for example, in the Wilson Art case here, this is one of the case, this is the case that kind of prompted the Florida Supreme Court to ask the parties to brief whether the summary judgment standard should be changed. There was video evidence basically disproving the plaintiff's claim that, you know, the defendant driver was negligent and caused this accident that killed the plaintiff. And to defeat summary judgment, the plaintiff offered an affidavit of an eyewitness or a testimony of an eyewitness that said this defendant driver changed lanes and caused the accident, even though that affidavit was refuted by video evidence. So under the federal standard, the plaintiff's evidence wouldn't have been sufficient to defeat summary judgment, but under Florida law, it would have. So although that, you know, the amendments to the rule are applying prospectively only as of May 1st, the outcome of that case could have been different if the federal standard had been applied. So next we'll discuss pretrial stipulations. Often the trial order will require the parties to file a stipulation outlining facts that are undisputed and won't require proof at trial, as well as factual and legal issues that remain to be decided. A pretrial stipulation will also usually include a list of each side's witnesses and exhibits. So beware that the pretrial stipulation is strictly enforced. So it's really important to make sure that it's accurate and complete. So example, if you stipulate that certain facts are undisputed, the appellate court and the trial court can hold you to that. And you also want to be sure that you did not stipulate to something that you didn't mean to, such as an unpled claim or defense by your opponent, or undisclosed witnesses or exhibits. And in a similar vein, failure to include issues in your pretrial stipulation can constitute a waiver of that issue. So next we'll talk about motions in limine. Under Florida statute 90.1041, if the court's made a definitive ruling on the record, admitting or excluding evidence either at or before trial, a party need not renew an objection or offer a proof to preserve a claim of error for appeal. So the definitive ruling language is key, however. So if the trial judge defers ruling on a pretrial motion in limine, or perhaps rules on the motion, but then states he or she will revisit that ruling once they've seen the evidence and, you know, the evidence is about to be introduced at trial, that's not necessarily a definitive ruling. So the statute would require you to renew your objection. So despite the statute, I always recommend that the safest course of action is to renew your objection, because as you know, as just discussed, sometimes it's not really clear whether you have a definitive ruling. And even if such a ruling was made, sometimes certain evidence presented at trial will open the door to the admissibility, to the admission of that evidence. And there could be an argument that even though the court ruled on the admissibility of evidence before trial, the circumstances have now changed, and this additional evidence opened the door to the admission of previously excluded evidence. Also, it's important to keep in mind that pretrial motions in limine are generally made while the trial judge has a limited understanding of the issues in the case. given that the court hasn't heard any of the evidence. So there's still a chance that the court can change its mind once it better understands the evidence in context. So there's a fourth DCA case that expressed this concept by stating the shifting sands of the trial in progress may cause a judge to rethink an earlier ruling based on a maturing understanding of the case. So I just recommend that renew the objection just to avoid any waiver there. Now, if your opponent introduces evidence at trial in violation of a prior order granting your motion in limine, make sure that you contemporaneously object, and if the trial court sustains your objection, move for a mistrial, or you might not be able to seek a new trial on appeal. And the rationale for that is you shouldn't ask the appellate court for relief that you never even requested from the trial court. So if you think that the evidence that your opponent introduced is just so prejudicial that its harmful effect can't be cured, you should ask for a new trial. So let's discuss now evidentiary objections outside of the motion in limine context. In other words, where neither side has filed a motion in limine. If your opponent introduces evidence that you believe is inadmissible, make sure that you make a contemporaneous objection stating the specific reason the evidence isn't admissible. If the court overrules your objection, there's nothing more for you to do to preserve the error. But if the court sustains your objection, again, move for a mistrial. And then if that's denied, you can request a curative instruction in the alternative if it's a jury trial. But make clear that you do want the mistrial, but you will take a curative instruction instead. Next, if the trial court has excluded evidence that you want to introduce, make sure that you make a proffer of that excluded evidence. Otherwise, the appellate court really won't be able to decide whether the evidence should have been excluded or not. So the purposes of a proffer are twofold. First, it includes the proposed evidence in the record, so the appellate court can determine whether the trial court's ruling was correct. But it also gives the trial court a full picture of the evidence and an opportunity to reconsider its ruling. So maybe once it hears the proposed witness's testimony, the trial judge will realize, this is relevant, or whatever the case may be, to reconsider its ruling. So how do you make a proffer? It depends on what type of evidence you're dealing with. So if it's documentary evidence, you'll want to identify the document on the record, describe its contents, and also explain why it's important to your case, so that not only the trial court has the benefit of that explanation, but the appellate court has it as well. And it's also very important to make sure that the document that was excluded makes its way into the record. So you'll want to provide it to the clerk who can mark it and make sure it's in there. Otherwise, again, the appellate court won't be able to see what it was. If you have testimonial evidence that's been excluded, the best practice, if you have a jury trial or a bench trial, is have the witness testify. If it's a jury trial, it would be outside of the presence of the jury. If for some reason the trial judge just isn't allowing that, doesn't want to spend time on that, at a minimum, I recommend that you identify your witness, describe in detail the witness's expected testimony, and again, explain why it's important to your case. So a proffer is not always needed when the substance of the excluded evidence is apparent from the context. However, again, the safest course of action to avoid waiver is sometimes just assume that the substance is not apparent, because that's really a subjective inquiry, and the appellate court might not agree with your assessment as to whether the substance would have been apparent. So just make the proffer. Now, if the trial court just blatantly refuses to allow you to make a proffer, that alone is generally reversible error. There is an exception where if the evidence was just completely irrelevant, or if you were trying to offer evidence on an issue that wasn't even before the court, such as an unpled claim. In that circumstance, the trial court does not have to allow a proffer, but under normal circumstances, they do. And if you want to learn more about proffers, there's a really great Florida Bar Journal article, which I've cited here on that topic. So we touched on the next issue a bit earlier, which is trial by consent. So let's say at trial, again, your opponent presents evidence on an unpled claim. You must object at that time, or you could be deemed to have tried the issue by consent, even though that issue was never raised in the pleadings, it wasn't included in the pretrial stipulation. If you allow your opponent to present evidence, you could be stuck with that. So for example, in the Certiorari case that I've cited here, that was a family law case where the trial court entered judgment prohibiting the parties from relocating the child without written consent of the other party or a prior trial court order. Even though neither party had even sought that relief in their pleadings, the Fourth DCA concluded that the parties tried the issue by consent by allowing evidence on it. So there are certain situations where a rehearing motion is required in order to preserve an issue for appeal. So if the error appears for the first time on the face of the judgment, you must file a rehearing motion. The Pensacola Beach case that I've cited here is the seminal Florida case on this point. Also, if the judgment fails to include required findings, you must file a rehearing motion. So a few examples of this are where the court fails to address Cozell factors. So that Cozell case sets forth the parameters for dismissing a case with prejudice or imposing similar sanctions for failure to comply with a court order. Another example of something that must be raised by rehearing is if the court fails to make findings on the reasonableness of an attorney's rate and the reasonableness of hours in an attorney fee judgment, you should raise that in a motion for rehearing. Because again, the theory is if you had raised this with the trial court, they may have been able to enter an amended judgment or an amended order and fix this issue rather than spending the resources of the appellate court to reverse. However, there are a few exceptions to the general rule that you must move for rehearing when there's a failure to make required findings, or if there's an order that appears for the first time on the face of the judgment. You need not move for rehearing where there's a split in authority between the DCAs about whether to move for rehearing where the trial court fails to make statutorily required findings in family law cases. So a rehearing motion is not required in the second and fourth DCAs, but in the first, third, and fifth DCAs, it is. So you want to be aware of that if you practice family law. And you also need not move for rehearing to argue that the trial court's factual findings made after a bench trial are not based on sufficient evidence. And that's because Rule 1.530E makes clear that the sufficiency of the evidence can be raised on appeal, even if it wasn't raised in a rehearing motion. So now now that we've covered what you need to do at the trial court level to ensure that you've preserved your arguments for appeal, we'll turn to the discussion of appealability of various types of orders and the actual mechanics of an appeal. So probably the most common question I get as an appellate attorney is when trial counsel comes into my office and they have an adverse order and they want to know, can I appeal this order? So to answer this question, I usually engage in a three-step analysis. First, I ask myself, is this a final order or judgment? And if so, it's appealable under Rule 9.110. If it's not a final order, then I ask, okay, is this one of the non-final orders that is appealable under Rule 9.130? And if it's not one of those non-final immediately appealable orders, then you have to assess whether an extraordinary writ is available by, filing a petition for cert or prohibition or mandamus. So I'm going to talk about each of these three options in a little bit of detail now. So first, for final orders, the test is whether the order constitutes an end to judicial labor in the cause and nothing further remains to be done by the court to terminate the cause as between the parties directly affected. So importantly, the substance of the order will control, not the title. So even if you have something that the trial court has labeled a final judgment or a final order or a non-final order, that's not going to be dispositive. The court will look at what the order actually does and not how it's labeled. So generally, in a final order, there's going to be some language of finality used where, judgment is hereby entered in favor of X party and so on and so on. So there are some tricky applications of the finality rule. So for dismissal orders, it's not as simple as just checking whether the dismissal order says a case is dismissed with prejudice or without prejudice. You might think that if the case is dismissed with prejudice, that's final. And if it's dismissed without prejudice, it's definitely non-final, but that's not always the case. Again, you have to look at what the order actually does. So for example, in this Carlton versus Walmart case that I've cited here, the dismissal order stated that the case was dismissed without prejudice to file another separate action. Well, in that case, it was a final order because there wasn't anything else for that trial court to do because they were saying a totally different action had to be filed. It wasn't as if the court was simply granting a motion to dismiss without prejudice to amend the complaint, in which case there would be further judicial labor. Another one that I often see brought to me is an order that grants a motion for summary judgment, but doesn't actually enter final judgment or otherwise use language of finality. There's lots of case law out there that says that an order that just grants a motion for summary judgment is not final. You actually have to obtain the final judgment. Now, if the order grants it says order granting motion for summary judgment, but it does use language of finality and actually enters judgment against the non-moving party, then that could be final. But again, you have to look and see what the order actually does, not how it's labeled. And another tricky application is you might be inclined to think that a final judgment, a final merits judgment that reserves jurisdiction to award fees is non-final because there's obviously more judicial labor to be done in that the court is going to be determining fees, but that's not the case. It's actually a final order, even if it reserves jurisdiction, because fee and cost awards are deemed to be collateral to the merits judgment. So another issue is the finality of fee orders and judgments. So an order that denies entitlement to fees is deemed to be a final order. And that makes sense because as to that issue, there is no more judicial labor to be done. Once the court denies your entitlement to fees, that's the end of the judicial labor on that issue. So there is an exception here, and that's the Scott case is one example of this that I've cited here. If the judge state that they're, denying fees without prejudice to revisit the issue later, then again, that's not really a definitive ruling. So you don't have the finality that you would need to make that a final order. And an order that grants entitlement to fees but has not yet determined the amount of fees is a non-final order. And that makes sense because if there's still more judicial labor to be done with regard to determining the amount, then it's not final. So another, just a practice pointer here is that when you're in doubt as to whether your order is final, just go ahead and file your notice of appeal so you don't miss a jurisdictional deadline. So if there's any doubt, really, the worst thing that's going to happen is the appellate court's going to dismiss your appeal for lack of jurisdiction. But on the other side, if you don't do the analysis correctly and you think that an order is non-final, but it is actually final, then, and you don't appeal it within 30 days, then you've blown the deadline, and the appellate court does not have discretion to extend a deadline for filing a notice of appeal. Once you've blown the deadline, you just totally miss your opportunity to appeal. So when in doubt, file your notice of appeal. If the court questions whether it has jurisdiction, it will generally enter an order asking you to file a paper explaining why you think that the court has jurisdiction. Also, there is a rule directly on point, Rule 9.110L, which I've quoted here, that says that if you file the notice of appeal before a final order is rendered, the appellate court has the option to either dismiss your appeal as premature, or it can give you additional time to obtain a final order from the trial court. And actually, the trial court has jurisdiction to render a final order, even if you have prematurely appealed. So the next topic is partial final judgments. Those are governed by Rule 9.110K. And that rule provides that a partial final judgment that disposes of an entire case as to any party must be appealed within 30 days of rendition. So let's say the plaintiff files a lawsuit against two co-defendants, and the plaintiff obtains a final judgment on all of the claims against one of those co-defendants, and no other claims against him remain, and he hasn't brought any counterclaims. He must appeal that final judgment within 30 days. Otherwise, he loses his right to appeal because that partial final judgment disposed of the entire case as to that one party. Rule 9.110K also provides that a partial final judgment that disposes of a separate and distinct cause of action that's not interdependent with other pleaded claims may be appealed within 30 days of rendition, or you can wait until the end of the case and appeal, 30 days after the final judgment disposing of the entire case. So an example of where this would come into play is, let's say you enter into a contract with your neighbor relating to the sale of your car, and the neighbor breaches that contract, so you sue for breach of contract. But at the same time, you're having a dispute with that same neighbor over trees that are growing over your property line. So you want to sue, you want to bring a property, some kind of action in property law on that issue. If one of those counts is disposed of and there's a partial final judgment on that count, you can appeal that now because it's really a totally different, independent and distinct cause of action, that the facts aren't interrelated. And so you have the option to appeal now or wait for later. So if you have counterclaims, generally if it's a permissive counterclaim, that's the type of claim that if it's disposed of by partial final judgment, that would be appealable. But if it's a compulsory counterclaim, meaning that it arose out of the same transaction or occurrence or same set of facts, then generally you're going to have to wait until the end of the case to appeal that type of partial final judgment. So that was step one of my analysis, was determining whether we have a final order. And those were the various, scenarios that I would look at. So let's say I don't have a final order. Now I want to know, if it's a non-final order, is it immediately appealable under Rule 9.130? And there are a lot of orders that are. And that when I say immediately appealable, I mean within 30 days of rendition of the order, there are certain types of non-final orders that you can take an appeal right away. So the rationale behind these is that allowing an immediate appeal of these orders is that these types of issues are best resolved sooner rather than later for purposes of judicial economy, or they're just really important issues that need to be resolved immediately. So for instance, the first one is orders that concern venue. There's another one, orders that determine the jurisdiction, personal jurisdiction. This makes sense to allow immediate appeals of these types of orders because, of course, if you're in the wrong venue, you want to get that fixed right away. You don't want to have to litigate the entire case in the wrong venue, or you don't want to litigate the entire case where you're saying the court doesn't have personal jurisdiction over your client to only have to, at the very end of the case, once you've gone through that whole process, then only then be able to appeal it. That doesn't really make sense. So I'm not going to read all of these, but you can see the different types of appealable orders under 9.130. And here I've listed a few more that are immediately appealable under 9.130. Note that subsection C10, orders that determine that a permanent guardianship shall be established for a dependent child pursuant to section 39.6221. That's a recent amendment in the past year or two that's been added to allow an immediate appeal of that type of order. So if you do practice guardianship law, you want to be aware of that. And also there were recent amendments in the last year or so on subsection F here, and that's appealability of orders that on sovereign immunity, absolute or qualified immunity. That was also recently expanded to allow an even broader set of non-final orders on those issues to be appealed. So if you don't fall within any of those categories of non-final orders that are immediately reviewable under Rule 9.130, then my next step in the analysis is to assess whether an extraordinary writ is going to be available. So if you want to appeal, to initiate a review in this circumstance, you actually have to file your petition with the appellate court. So that's a little bit different of a process. So when you have an appeal from a final or a non-final order, you are going to file your notice of appeal with a trial court. Whereas under Rule 9.100, which governs extraordinary writs, you're actually going to file your petition, which is similar to a brief, with the appellate court and pay your filing fee to the appellate court. So there's a lot of available writs, and here I've listed their uses. So cert is probably the most common writ that we see issued, and that's where the trial court has departed from the essential requirements of law, and there's no remedy on there's been a material injury that can't be remedied on direct appeal. Prohibition can be used to restrain an improper exercise of judicial power, but it's only used to restrain a future act, not to correct prior acts that are already performed. So probably the most common use of this writ is when you have a motion for judicial disqualification that's been denied. You can file a petition for writ of prohibition and essentially ask the appellate court to determine that that trial judge should no longer be presiding over your case in the future. Mandamus is used to enforce an established legal right by compelling a party in an official position to perform a legal duty required of his or her office. So, but note that it has to be a ministerial duty, not a discretionary duty. Quo warranto is Latin for by what authority. And that writ is most often employed to determine the right of an individual to hold public office or to challenge the officer's authority to exercise a right or privilege derived from the state. Habeas corpus, determines the propriety of, detaining somebody or legally restraining someone. And then all writs jurisdiction is not an independent source of jurisdiction, but it is an ancillary power that's used to protect jurisdiction conferred elsewhere. So a full discussion of all of these writs is going to be beyond the scope of this CLE. So I'm just going to briefly touch on the writ of certiorari, which is probably the most common one that we use. So not all of the extraordinary writs have a hard deadline for filing of the petition, but the petition for cert does. That has to be filed within 30 days of rendition of the order. And as I noted earlier, unlike an appeal from a final order or a non-final order where you file your notice of appeal and then your briefing deadline stems from the date that you filed the notice of appeal, for petitions for cert, you actually have to file your whole brief 30 days after rendition of the order. So you want to make sure you're not waiting until the 29th day thinking, oh, I've got time, I'm just going to be filing some kind of notice. You're actually filing your full brief with all of your arguments. And it's important to keep in mind that certiorari jurisdiction is very limited. So the petitioner must show that there is a material injury that can't be corrected on appeal, plenary appeal, so the appeal at the end of the case, and that the trial court departed from the essential requirements of law. So these first two elements are jurisdictional in nature, and the court will analyze those elements before turning to the third element. So it's really important. There are lots of cases where perhaps the trial judge has departed from the essential requirements of law, but if you can't prove that you have a harm that can't be remedied on your direct appeal, then you're not going to be able to establish cert jurisdiction. There is case law that says that an unnecessary expenditure of time or money in, dealing with an issue in a case, that's not a material injury that can't be corrected on appeal. So keep that in mind. And then if you're wondering what the essential requirements of law is referring to, there's case law that says that is found in case law on the issue, interpretation or application of a applicable statute, procedural rule, or constitutional provision. So when we say the essential requirements of law, it really encompasses all of that. Okay, so I think this is a good stopping point for the 5-minute breaks because I'm about to get into a different topic. So let's see, it's 10:48 now. So if we want to come back at 10:55.
Sounds good. I'll see everyone in 5 minutes.
All right, thanks. All right, welcome back. I just realized there was one slide on the cert issue that I didn't cover, and I have here several examples of uses of the writ of certiorari. So as we just discussed, the petition for writ of certiorari can be used when there's a material injury that can't be remedied on direct appeal, and there's been a departure from the essential requirements of the law. So we do have some examples here. The discovery orders that would result in cat out of the bag harm. So for instance, if the trial court has ordered you to disclose attorney-client communications or trade secrets, those are things that, once your opposing counsel becomes aware of them, there's no unringing that bell. So that is the type of harm that is deemed to be not remediable on direct appeal. A few other examples are orders abating or staying trial court proceedings, as well as discovery orders compelling production of documents by a non-party. So now we'll get into a discussion of the mechanics of an appeal. So let's turn back to, let's say we have an appeal from a final order or a non-final order that is immediately appealable under Rule 9.130. To initiate review and invoke the appellate court's jurisdiction, you must file a notice of appeal with the clerk of the lower court within 30 days of rendition of the order and pay the filing fee. So rendition is a term of art in the appellate world that's actually defined in the rules of appellate procedure at Rule 9.020H. And that rule provides that an order is rendered when a signed written order is filed with the clerk of the lower court. So if you have an order if you just have an oral pronouncement from the judge, obviously that's not going to comply with the rendition requirement. You can't appeal an oral ruling. You need an actual written order. Or if the judge, somebody, they just haven't signed the order for whatever reason, that also would not be considered rendered yet. Another issue is, for instance, I have one case that it's a Miami-Dade case, but it's presided over by a Broward judge, and there's usually a delay between the time that the judge will serve us with the orders by email, but then there's a several day delay usually by the time the Miami-Dade clerk has filed that order with the clerk. So for purposes of appeal, the date would be not the date that the order is served on us, but the date that it's actually filed with the lower court clerk. And also I noted here that if you're not sure what a notice of appeal should look like, there are form notices available at the very back of the rules of appellate procedure. There's Rule 9.900 has all kinds of forms, not just notices of appeal, but all kinds of stuff in there. Okay, so I just mentioned that the orders are deemed rendered when a signed written order is filed with the lower clerk, the clerk of the lower tribunal. But under Rule 9.020H1, certain, quote, authorized and timely motions will toll rendition. And that rule lists all of those motions, but I think the most common ones are motions for rehearing, motions for new trial, motions to alter or amend a judgment, motions for judgment in accordance with a prior motion for directed verdict. And if an authorized and timely motion that's listed in this rule has been filed directed to a final order, then the final order is not deemed rendered until a signed written order disposing of the last of such motion is filed with the clerk, or if you've moved for a new trial and the court grants that motion. And so if there's an order granting a new trial, then tolling will conclude even if there were other tolling motions pending at that time. But the key words here are timely and authorized. So the specific rules of civil procedure will tell you exactly how long you have to file, for instance, a motion for rehearing, a motion for new trial. I've given one example here, is that rehearing motions must be filed within 15 days after return of the jury verdict or the date of the filing of the judgment in a non-jury action. And authorized means that it has to be authorized under the rules. So rehearing motions are only authorized if they're aimed at a final order. So if you file a motion for rehearing aimed at a non-final order, that is not going to toll your time for appeal of that non-final order under Rule 9.130, because that's not a rehearing motion is not authorized for non-final orders. If you have a non-final order, you would file a reconsideration motion, but the rehearing motions are only for final orders. So there's been a recent amendment to Rule 9.110D, which is the rule that discusses your notice of appeal for a final order. So that rule now provides, it just went into effect, I believe, January 1st, that if a motion postponing rendition pursuant to 9.020H is pending while when the notice of appeal is filed, the notice of appeal, you actually have to state in your notice of appeal now that that motion is pending and the date it was filed. So before, you would file your notice of appeal from a final order, and if you had a rehearing motion pending and the judge hadn't ruled on it yet, there wouldn't necessarily be a way for the appellate court to know that unless you filed a motion notifying them. Whereas now your notice of appeal actually has to say that if you have a motion pending. So if you do file your notice of appeal before an order disposing of, for instance, your motion for rehearing, your appeal will be held in abeyance until the trial judge files an order disposing of your rehearing motion or any of the other motions that are listed in Rule 9.020H1. Okay, so you filed your notice of appeal and now you're getting ready to prepare your brief and gonna take a look at the record. So the record on appeal is transmitted in appeals from final orders. So if you have an appeal from a non-final order, or if you're filing a petition for extraordinary writ, you're going to be doing an appendix instead, because the record is not transmitted in those types of cases. They're only transmitted in final order appeals. So Rule 9.200A1 outlines the items that are automatically included in the record. So note, however, that certain documents such as subpoenas, summonses, returns, notices of hearing, notices of taking deposition, things like that are not automatically included in the record. So if you have a case where you think you're going to need to cite any of those materials in your brief, then you need to make sure that you get those items in the record, especially if you're the appellant. So for example, if you want to argue that the trial court violated your client's due process rights by holding an evidentiary hearing that wasn't properly noticed, you'll want to include the notice of hearing in the record to show that it wasn't noticed as an evidentiary hearing. So that's just one example of where you might need that. So what do you do if there are documents that aren't automatically included that you want to be included? You're going to file directions to the clerk within 10 days of filing your notice of appeal. And that requirement is stated in Rule 9.200A2. If you don't know what directions to the clerk look like, luckily there is a form available in Rule 9.900G. So just take a look at that. And also, if there's been any portion of the proceedings that have not been transcribed by your court reporter or included in the record at the time that you filed your notice of appeal, you're going to have to file a designation to court reporter and serve it on the court reporter. And then the court reporter will have to prepare the transcript within a certain number of days to get that in the record. So again, that is required by 9.200. I believe there's also a form available on that at the end of the rules of appellate procedure. Another note is that let's say you already have the trial transcript before you file the notice of appeal, but you've ordered a condensed transcript, meaning the one that has the four pages of transcripts on a single page. You can't file that in the record. That's an amendment that went into effect probably the last 5 years or so. You have to actually file the full page trial transcript, not a condensed trial transcript. So very, very important principle of appellate law is that the appellant has the duty to provide the appellate court with a sufficient record. And if they don't do that, then the court can affirm just based on the fact that they don't have a record that demonstrates error. So if you're the appellant and your record is incomplete, so meaning something that should have been included in the record, sometimes the clerks do make mistakes and don't include everything that should have been there, make sure you file a motion to supplement. So what I generally do is as soon as the clerk will serve on you an index to the record on appeal before they actually serve the record itself, and the index will just list everything that's going to be included in the record. As soon as I receive that, I go through it and I make sure that it has everything that I'm going to need for my appeal, because you definitely don't want to get in a situation where you've got a brief due in a few days and you just realize that something really important just isn't in the record. You can file a motion to supplement the record and that will actually toll your time for the brief, but you just don't want to put yourself in that kind of situation if you don't have to. So it's a good practice to just take a look at that right away. So, and remember that preserving the record starts at the trial court. So it's important to create a record that can bring the appellate court into the courtroom with you. So these appellate judges are just reading, a pretty cold record. So they're not able to actually see what was happening at trial. So for example, you'll definitely want to note any significant nonverbal conduct on the record, because the court reporter generally is just taking down spoken word. They're not taking down gestures and crying and things like that oftentimes. So if you have a witness who's crying, if you have a juror who's sleeping, if your witness is pointing to something, let's say they're looking at a document and they're just pointing at it, but they're not explaining what they're pointing at, you'll definitely want to just say, for the record, she's pointing at, lines 3 through 5 of her deposition testimony or something like that, so that the appellate court, when they're going back and reading that, they know what's being pointed at. Also, if someone's making improper gestures, if you have an opposing counsel who's flailing his arms and stomping his feet and things like that, that wouldn't be recorded by the court reporter, you want to make a note of that. Also, something that I've seen happen is, if the judge calls a sidebar, you want to make sure your court reporter gets up there and records that sidebar with you, especially if the judge is making rulings that you think you might want to appeal. Another thing is make sure that all of your exhibits, demonstrative age, are filed with the clerk. And as we discussed earlier, if there is a document that you were proffering that was excluded, you want to make sure that's filed with the clerk, because again, the appellate court is not going to be able to determine whether it was error in excluding these things unless they've actually able to see them for the most part. So whether you actually need, I would say best practice, just to at the outset note, is always have a court reporter transcribe your hearings. Because even if you think it's not going to be a very important hearing, maybe the judge wants to raise something or opposing counsel raises something that wasn't noticed or that you just weren't expecting that would require an appeal at some point, you do want to have a record of that. But, obviously I understand sometimes there's budget concerns and you might be trying to figure out whether you really need a court reporter. There is a few different cases on whether you need a transcript of a summary judgment hearing for the appellate court to review to be deemed to have a sufficient record on that issue. So the transcript of the summary judgment hearing may not be needed if the record includes the opposing party's response to the summary judgment motion, because as the third DCA noted in this Gonzalez case that I've cited here, the summary judgment hearing in that case will just consist of counsel's legal argument, which is already going to be in the record. because it's in the summary judgment motion and it's in the response to the summary judgment motion. So the appellate court doesn't necessarily need to see the transcript where the parties' positions were already laid out in the summary judgment papers. However, if you get into a situation where your opposing counsel started raising arguments at the hearing that were not raised in the papers, in that situation, that goes back to my first point, that it is the best practice to always have a court reporter. But if you find yourself in a situation where you didn't have one at a summary judgment hearing and you're questioning whether you have a sufficient record, you might be able to use this case. However, if no opposing summary judgment motion, response or evidence was filed, then you likely do need a transcript, because the appellate court won't be able to tell what was argued in opposition to the motion. So especially if you were the party against whom summary judgment was entered, then you are going to need that, because you have a preservation requirement to show to the appellate court that you did raise this argument below and the trial court rejected it. So if you can't show that with your transcript and you didn't file anything in response, then you're going to have a really hard time showing that. So as I mentioned before, the record on appeal is only transmitted in appeals from final orders. If you do have a non-final order appeal or an extraordinary writ proceeding, you have to actually prepare your own appendix that you're going to file with your brief or petition. And you get to choose what's included in that appendix, but obviously it's going to be, for instance, if you're appealing an order denying a motion to dismiss for lack of personal jurisdiction, you want to have all, the complaints, the motion to dismiss, the response, a reply. If there's a hearing transcript, you get to choose, but you want to be smart about not being, you don't need to include everything that was ever filed if those other items are not relevant to the specific issue that you're appealing. And Rule 9.220 outlines the appendix requirements, and there are very, very specific requirements on electronic appendices. And I've seen a lot of brief appendices get stricken for failure to comply with those requirements. So make sure you're taking a really good look at that rule if you're preparing an appendix. So for instance, it has to be OCR searchable. You have to have Bates numbers at the bottom of the pages. And those numbers actually have to start on the cover page of your appendix, which is a little counterintuitive. So that's probably one of the #1 reasons I've seen appendices get stricken, is for failure to comply with that part of the rule. So you're preparing your brief and you're trying to determine what the applicable standard of review is on appeal. This is going to be one of your first steps in determining whether you can establish that the trial court has actually committed reversible error. So the standard of review is the criteria that's used by the appellate court to evaluate the trial court's decision. So the trial court's orders do have a presumption of correctness, which applies to all trial court decisions except for orders that declare a state statute facially invalid. And as the appellant, you will have the burden to overcome this presumption by showing reversible error. So the standard of review that applies will depend on the nature of the ruling. So if it's a conclusion of law, the de novo standard will apply. If it's a discretionary decision, the abuse of discretion standard will apply. And if it's a finding of fact, the competent substantial evidence standard will apply. And these standards basically describe the level of deference that the appellate court's going to give to the trial court's decision. So the de novo standard, as I just mentioned, legal conclusions will be reviewed de novo, and the appellate court will assess whether the applicable issue of law was correctly decided by the trial court. So under this standard, you're essentially giving no deference to the trial court's decision. Although trial court decisions are presumed correct, the appellate court is free to decide the legal issue differently without deferring to the trial judge's view of the law. So if you're the appellant, because this is the least deferential standard of review, if there's any legitimate way to frame your issue as one that to which a de novo standard would apply, you want to try that. The types of decisions that are typically subject to de novo review are orders dismissing a complaint for failure to state a claim, the trial court's interpretation of a contract, or summary judgment orders. There are lots of other examples too, but these are just a few legal issues that commonly come up. The next standard is the abuse of discretion standard. So just as I noted earlier, discretionary decisions are reviewed under this standard. So mere disagreement with the reasoning or the decision of the trial court is not enough to justify a reversal under this standard. Rather, you have to show that no reasonable man would rule as the trial court did, which, as you can imagine, is pretty tough to show. And the rationale behind this standard is that the trial judge is in the best position to resolve these discretionary issues. So, yeah, and this Canacaris case is the seminal Florida case that outlines the standard, the abuse of discretion standard. So the types of decisions to which the standard is usually applied is many evidentiary rulings, but it depends on the nature of the ruling. So abuse of discretion would apply to relevance, rulings under section 90.403's balancing test of relevance and unfair prejudice. But because hearsay is really a legal issue, the standard of review on that evidentiary issue is actually de novo. And I say typically here just because sometimes there is a way to argue that the trial judge just totally misconstrued and misapplied the evidence code, or maybe just didn't even apply the correct portion of the evidence code. And in that case, you might be able, even if it's a relevance issue or something that would normally be subject to abuse of discretion, there might be a way to argue that the de novo standard applies. Other discretionary rulings are sanctions orders, orders on injunctive relief, and amount of attorney's fees. So finally, factual findings are going to be reviewed for competent substantial evidence. This is a very deferential standard as well. And the rationale is that the trier of fact has the opportunity to evaluate the evidence and to weigh the testimony based on an observation of the witness's demeanor. So they're really in the best position to make these factual findings. In case you're wondering what competent substantial evidence means, there is some case law defining this standard. Competent evidence refers to admissible evidence, and substantial is, in my view, a little bit of a misnomer. It really just means as long as there's some evidence to support the finding, then that's considered substantial. And one prior CLE, I think one of the appellate judges said that if you have 5 witnesses and 4 of them said the light was red and 1 of them said the light was green, well, that's enough to be substantial. If you find the trier of fact finds the light was green, the fact that you had 1 witness testify to that would be considered to be substantial evidence because there's at least some evidence to support the finding. It doesn't have to be the greater weight of the evidence. So now we're going to just go over a few key appellate doctrines that you'll want to have in your back pocket when you're either bringing an appeal or defending an appeal. So we have the invited error doctrine, the tipsy coachman doctrine, the harmless error doctrine, and the fundamental error doctrine. So invited error essentially means that a party who has requested a certain action in the trial court waives the right to challenge that action on appeal. So in other words, be careful what you wish for. If you ask the trial court to do something and the trial court does it, then you can't thereafter say, well, you know, the trial court was wrong and should never have done that on appeal. You invited the error, so you're stuck with it. And this applies even if the error would have amounted to fundamental error, which is a pretty harsh, but again, it goes to the principle that you can't benefit from asking the court to do something and then complaining about it on appeal. So some examples of this are if you file a motion asking for certain relief, you can't argue that the trial court erred in granting that relief. You can't offer evidence and then argue that the trial court never should have admitted that evidence. That's invited error. So the Tipsy-Coachman doctrine is very important, especially if you're the appellee. And it essentially stands for the proposition that if the trial court reached the correct outcome, but its rationale for its decision was wrong, the appellate court can still affirm that decision as long as there's some basis in the record to support it. So the rationale behind this rule is judicial economy, really, because the appellate court is not going to reverse a judgment just to have the trial court come to the same result, but provide a different explanation for that result. So if you're the appellee, you typically don't have to you don't have to have preserved this argument, whatever the alternative argument is that the appellate court is going to rely on below. And the Dade County School Board case that I've cited here explains that. There are certain exceptions to that rule. So in the Loringer case that I've cited here, the court held that the Tipsy-Coachman doctrine doesn't apply in summary judgment proceedings where the issue was never even raised in the motion for summary judgment. So again, if you're the appellee, and let's say you realize, yeah, the trial court's decision actually was wrong. If there's any other way to if the court got the outcome right, but just kind of gave the wrong rationale for it, you might want to raise that in the brief. So there are some limitations to the Tipsy-Coachman doctrine. For instance, it can't be applied where the argument would require findings that were never made by the trial court. And the rationale behind this is that the appellate court, it's not their function, and they're really not equipped to make factual findings. That's the function of the trial court. The next appellate doctrine is harmless error. So our state has had a harmless error rule ingrained in its statute since 1911. And the statute essentially provides that you can't get a reversal unless after examining the entire case, the court decides that the error resulted in a miscarriage of justice. In other words, not all error will be deemed reversible error. So for example, an error in admitting certain evidence might be considered harmless if that evidence was cumulative to other evidence that was properly admitted. So if on appeal you argue the trial court erred in allowing a witness to testify on a certain issue because that testimony was just hearsay, but there were 3 other witnesses who testified to the same exact thing, then the error in admitting the hearsay would be harmless because the court could have still reached that result without the hearsay evidence. So until 2014, the Florida case law typically assumed that the appellant had the burden to prove that an error was actually harmful. But in 2014, the Florida Supreme Court decided this Special versus West Boca Medical Center case that I've cited here. And they kind of changed the landscape by holding that the error that applied in criminal appeals, the harmless error rule that applied in criminal appeals now applies in civil appeals as well. And the test is that the beneficiary of the error, in other words, the appellee, now has the burden to prove that the error did not contribute to the verdict or that there's no reasonable possibility that the error contributed to the verdict. And the appellate court must focus on the effect of the error on the trier of fact and avoiding engaging in analysis that only looks to the result in order to determine harmless error. So an example of harmless error in a civil case would be if there was an error in a jury instruction on damages, that could be harmless if the jury found that the defendant wasn't liable at all, right? So the jury never even got to the issue of damages because they decided there was no liability. And the last doctrine that I wanted to discuss today is fundamental error. So this is an exception to the preservation of error rule that you've heard me mention a few times today. Florida case law defines fundamental error as error that goes to the foundation of a case or goes to the merits of an action. The appellate court has the power to correct fundamental errors, even if you didn't timely object in the lower court. And as I previously noted, this is extremely rare in civil cases. In criminal cases, you'll see it found a bit more often. But some examples are the denial of the right to be heard in violation of your due process rights. If the court has entered a judgment against a non-party, that's fundamental error, or lack of subject matter jurisdiction. If the trial court didn't even have subject matter jurisdiction since the beginning of the case, that can be raised even if it wasn't raised below. So now we're going to take a look at a few different types of common appellate motions that are filed. First is the beloved motion for extension of time, usually to file a brief, and these are governed by Rule 9.300A. That rule requires you to certify that you consulted with opposing counsel about the extension and that they either agree to your extension or they oppose it and will promptly file an objection. The filing of an extension motion does toll the time for your brief until you obtain an order on it. So that is helpful. And all DCAs have administrative orders. They're all posted on the websites that govern agreed extensions of time in certain appeals. So appeals from final orders, you can agree with opposing counsel. Some of the districts say you're limited to, for instance, like 90 days or 60 days for an initial or an answer brief, or you're limited to 15 days for a reply brief. But you essentially just, instead of filing a motion asking the court to enter an order, you're just going to file a notice and it's pretty much self-executing. Some of the DCAs will issue, a little order or email order that just acknowledges that they received it. But for the most part, once you file that, as long as you've agreed with opposing counsel, you'll get your extension. And as long as you haven't exceeded the total extensions that are allowed under that order. And the orders actually have these administrative orders have the exact language that they want you to use in the notices of agreed extension. The fifth DCA does also require for extension motions that you certify that you've provided your client with a copy of the extension motion or the agreed notice. And in your certificate of service, you have to include that certification. And I think, the rationale behind that is maybe the court felt that these extensions of time on briefs were getting a little out of hand, and they wanted to make sure that the clients were actually aware of this, that all of these extensions were being taken to maybe, encourage the parties to not take so many. And then finally, I already mentioned that the filing of the motion will toll the time for your brief, and that's under Rule 9.300B. The next are appellate motions for rehearing, which are governed by Rule 9.330. And when I'm referring to appellate motions for rehearing, I mean the appellate court has issued an opinion, a written opinion, and you want to challenge that. So this has to be filed within 15 days of the order or decision, or within such other time set by the court. So sometimes the appellate court will issue an order shortening the time for rehearing motions. if you're in the Florida Supreme Court and you've tried to appeal something that's just not even within the Florida Supreme Court's jurisdiction, I've seen orders issued that say no rehearing motions will be entertained. So that, they're allowed to do that. So the standard for rehearing, though, is very limited in appeals. The motion has to identify with particularity the points of law or fact that the movement believes the court is overlooked or misapprehended in its order or decision. And the rule specifically warns that you should not present issues that were not previously raised in the proceedings. So this is not, rehearing motions should not be used as an opportunity to simply re-argue the merits of your case or, basically take issue with the way that the judge decided the opinion. It really has to be limited to issues that were overlooked or misapprehended. And there are lots of appellate opinions kind of expressing disdain for what the appellate judges believe to be an abuse of the appellate rehearing process. So there's cases that say they're really rarely appropriate. You have to limit it to the grounds that are allowed in the motion. It's not appropriate to just express your displeasure with the court's ruling or re-argue issues that the court rejected in its ruling. And it's also not proper to file a motion for rehearing when the court has just issued a PCA, because if there's no written opinion, then obviously there's no real basis for you to argue that the court overlooked or misapprehended something when you don't even know what the basis for the court's decision was. It could have been preservation. You didn't preserve the error and they don't want to call you out for that in an appellate opinion that says that. So like I said, there's a lot of, you can be sanctioned if you file a rehearing motion that doesn't comply with the rules. Here's one 4th DCA case that really reamed somebody out for filing an improper motion for rehearing. I know there are a lot of other more recent cases that hold the same. So I guess the point is, file these at your own risk, because you really should rarely do this unless you have a proper basis for it. So next is going to be motions for appellate fees. And these are governed by Rule 9.400B. The time for service is no later than time for service of the reply brief, or if it's an original proceeding. So if you've filed a petition for extraordinary writ, then your time the time for filing the fee motion is the time for service of petitioner's reply to the response to the petition. There are different requirements for fee motions in Florida Supreme Court discretionary appeals, and I've cited the rule there in case that's something that you handle. And your appellate fee motion can be pretty short. You can just state the basis for entitlement to fees. So oftentimes that's going to be statutory or contractual entitlement. And then what happens is, the appellate court will enter an order on entitlement, but they generally remand to the trial court to determine the amount of fees. Again, that kind of goes with the concept that appellate courts aren't really there to make findings of reasonableness and things like that. So oftentimes they'll remand that. So just as of the beginning of this year, there were many, many amendments to the Florida Rules of Appellate Procedure that went into effect. So I'd encourage you to just take a look at the opinions that I've cited here. There are 4 opinions that came out in 2020 that discuss various amendments. And then there were some other 2020 amendments that went into effect before January 1st. So I've given the opinions here that outline them all, but just a few I'll note quickly are the font requirements for appellate filings. This isn't just briefs, it's also motions. I have seen motions get stricken for failure to comply with this. So now instead of the Courier New or the Times New Roman, The font is Bookman Old Style or Arial for 14-point font. So make sure if you've handled any appeals, you've probably gotten a lot of these email notices from all the DCAs reminding you of this. But another change was that rather than having a 50-page limit for an initial or answer brief, now you now have word limits. So they've pretty much, federal court has been doing this for a long time, but now we are doing it as well. So for word processed briefs, you're going to have to provide the word limit, and there are certain exclusions like the cover page and things like that don't count, but in certificate of service, but the body of the brief will. If you handle a lot of county court cases, you've probably heard that the DCAs now have jurisdiction over most appeals from county court orders. So rather than go to the circuit court appellate jurisdictions, they now go to the DCAs. And there's a really handy chart on right here that I've provided the link for that. That has the types of appeals that will still go to the circuit court appellate division. As I noted earlier, you have to note the pendency of any rehearing motions or other tolling motions in your notice of appeal from a final order now. The record has to be transmitted by the clerk within 60 days after filing the notice of appeal rather than 110 days. This is a great change for people who practice appeals because, from an appeal from a final order, your brief is due 70 days after the filing of the notice of appeal, but it used to be that the clerk had 110 days to transmit the record. So oftentimes you'd be in a situation where your brief was due, but you didn't even have the record available yet. So now they've fixed that, and now the record is due 10 days before your brief is due. So yeah, there's a lot more amendments. It's just not enough time to cover all of them today. So if you want to learn more, just check out all these opinions that I've cited here. And if you're interested in learning more about appeals, the Florida Guardian Ad Litem program actually has a great YouTube channel that provides a lot of free CLEs on not only appellate practice, but a lot of other topics as well. And I've listed the website for that here. Most notably, about 3 weeks ago, the appellate practice section pro bono committee just did a half-day CLE on various issues on appeals. So I did a CLE on contemporaneous objections, which if you handle a lot of jury trials, that CLE had a lot more discussion of, jury instructions, jury selection, verdict forms, jury misconduct, things like that. But then there were also other CLEs on, for instance, the motions for rehearing and motions for reconsideration. And let's see, there's a motions in limine section. So all of these segments were either in half-hour or hour increments if you're interested in getting the CLE credit. Another thing is join the Florida Bar Appellate Practice section. Padavano's appellate treatise is a go-to for me. And also, I should have put here, Shutts has an appellate blog. So if you want to subscribe to that, there's a lot of good content on there. So that concludes my presentation, and I'm happy to take any questions that you guys might have.
Thank you so much, Amy, for such an in-depth presentation. I know that's a lot of work doing a 2-hour training, so I really appreciate you doing that. We did have a couple questions come in, and while people are typing in questions, I did want to announce the CLE number is 2009-702N. Again, that's 2009-702N, and I'll also type that in the chat and send it with the follow-up email with the recording. So let's get to the questions. All right, the first question is, if the error occurs in the non-final hearing, is it correct that you would have to file a motion for reconsideration?
So I think what you mean is if there's an error in a non-final order, is it required? So like I had mentioned earlier, there are certain situations where you do have to file a motion for rehearing if there's an error that appears for the first time on the face of the judgment. The motion for reconsideration of a non-final order, I guess it would depend on what the issue is, but there's not really a requirement that I'm aware of that you would have to do it. And also keep in mind that motions for reconsideration do not toll your time for appeal. So under Rule 9.020, as I mentioned, it's only those timely and authorized motions that toll the time for your appeal. So although it's certainly a good practice if you think that the trial court just kind of went off the rails and addressed an issue that was never even argued by the parties or something along those lines, if you want to file a motion for reconsideration, I think that's a good practice. But just be aware that if you don't get a ruling on that in 30 days, and it is one of those orders that's appealable under Rule 9.130, that's not going to toll your time. So what you can do is file your notice of appeal, and then you can also file with the appellate court a motion to relinquish jurisdiction to allow the court to rule, the trial court to rule on your reconsideration motion.
Okay, great.
That answer? Yeah.
Yes. Important to know about the deadlines. Okay, this person says it's going to be an easy question. Do you prefer Bookman old style or Arial font for briefs?
I like Bookman old style, but you know, I clerked at the 5th DCA for a few years before I went into private practice, and all of our memos and everything they were written in Arial. So I don't know if that means the judges prefer that, but yeah, I just like the look of it. It looks a little less plain to me, but I know there's arguments on both sides.
All right, let's see if we have any more questions coming in. I don't see any at the moment. Don't be shy. Got to get them in while we have our expert on the line. That must mean you covered absolutely everything.
It's a lot of material. But if anybody thinks of something, you know, has a question afterwards that they don't want to ask now, or just they don't think of it until later, you're welcome to email me at ajones@shutts.com, SHUTTS.
All right, I'm going to put that in the chat. ajones@shutts.com. I had some compliments come in. And then also someone asking, is there a case that can be used as guidance for drafting final orders?
I mean, I think it depends on what the final order is. Now, of course, there are form final judgments at the end of the rules of civil procedure, and they break it down by whether it was a jury trial or a non-jury trial that you can use. Again, it depends on the issue. But yeah, if it's just like a money judgment or something along those lines, you can use those forms. But there's not necessarily like a single case. There's just case law that kind of talks about the end of make sure it's the end of judicial labor. And there's a lot of case law that discusses words of finality that can be used to indicate that it is a final order.
Okay. I just typed in the chat box the website that Amy mentioned for the half-day training, and I will try to remember to put that in the follow-up email also. So you have that.
Yeah, and the half-day training, just to let you know, if you don't want to sit through all, I think it was 5 hours, you can just pick and choose which topics interest you. So you can do a 30-minute segment on motions in limine. You can do an hour on contemporaneous objections. So you don't have to do the full 5 hours. There's the YouTube, this channel. I know that they were not posted yet as of last week, but it might be another week or two before the January 13th CLEs are posted, but they do have a lot of other CLEs from last year's Florida Bar Winter meeting that are already on there that pertain to appeals.
That's a great resource to keep in mind. I'll definitely check that out. We did have a couple more questions come in. For final orders, can you file both an appendix and have the clerk send the record?
Yes, you can. If you think like if you just want to have the court, if you just want to provide a few very key materials in the appendix, you can. There's not necessarily a reason that you need to, unless you just want to make it really easy on the court. But again, the courts, these records are transmitted electronically, so they have everything on their computers. So if you give them the exact record sites, you don't necessarily need to, provide an appendix when you already have a record.
Okay, and someone had a question about any suggestions for handling the requirement for an appellate bond when working with indigent clients.
So appellate bonds, if you have a money judgment, there are certain, I think you're referring to when you're trying to obtain a stay of a judgment pending appeal. If you have a money judgment, you can post a bond. And that in certain DCAs operates as an automatic stay. Well, in all DCAs if you post it, but there are certain DCAs, and it's slipping my mind which ones are which, but that hold that the posting of a bond is not the only way that you can obtain a stay. So the trial court has discretion to impose other obligations. So you can look up those cases and see if you're in one of those. I believe it's 2 DCAs that hold that you don't necessarily have to post a bond to get a stay of a money judgment. That's not the only way to get it. You could try that, and then if it's not a money judgment, if it's declaratory relief or injunctive relief or something along those lines, then the bond doesn't necessarily come into play. You can ask the judge to impose other conditions as well.
Okay, good. Sounds like there's lots of options there. And last question I see is a motion for summary judgment in favor of one co-defendant a final order or non-final order?
So if you have an order that merely grants a motion for summary judgment, again, if it doesn't actually enter judgment or use language of finality, that would be a non-final order. But if your summary judgment motion has been granted and the court actually entered final judgment against that defendant, and that was the only claim against that defendant, then that's a partial final judgment that would be immediately appealable under 9.110K.
Fantastic. Thank you so much for sharing your expertise with us for the entire morning today. I really appreciate it. And I also want to thank you and your firm for all the pro bono work you do for clients that we serve in legal aid. And I don't want to let everyone go without acknowledging that I have a huge debt to Alicia Herwood at Coast to Coast Legal Aid for introducing me to Amy and being able to bring this presentation to a statewide audience. So I really appreciate you, Alicia and Amy, for doing this. Thank you.
Well, thank you for having me. I'm happy to be here.
Thank you. Lots of compliments in the chat box. So thank you again for doing this, and everyone have a good day. Bye-bye.